Well, hello. This is Tracy B from the Divorce Solutionist. This is my weekly live video stream, I guess that's what you call it. Think of it Thursday. Yes, it is Thursday. It is Think of It Thursday time. And this is the time that I use to go through a topic, either a fact pattern, hypothetical, real life situation of a client of mine or just someone that I read in one of the various groups that I administrate or that I'm very active in, or just someone who reached out to me and asked me a question. And I'm like, great topic for Think of It Thursday live stream. So that is what this is. Think of It Thursday live stream. So I am sorry, I am looking at my notes because this has been a crazy week. And sometimes I fly off the cuff with what I want to talk about, but because it's been such a crazy week, I have to actually look at my notes to stay on course. So, as I mentioned on my business page and in my group, The Divorce Glow Up, today's topic is things to consider during the divorce. What I wanted to talk about today was some of the things that people forget, overlook, or are completely oblivious to consider while the divorce is pending. I'm not talking about the actual divorce itself, like the serving and the discovery and all of that stuff, although those are very important topics. I'm talking about some of the things that your lawyer might not tell you, your friends who are who have gone through the process might forget to tell you or may not even know. Support groups may not tell you, or you just don't know, or maybe they did, or you didn't understand, or you forgot, or whatever. So these are some of the things I wanted to talk about, some of the things that will affect the how smoothly your divorce goes and actually post-divorce. So and this week's topic is not just for those who are actually already going through a divorce, but if you're considering it, if you've already gone through it and you're post-divorce, there may be some very valuable tips here as well. Now, I have a list with a long list of things that I wanted to talk about. I don't think I'm going to get through them all today because I don't want to be talking for all night, because I do have other things I need to tend to today. But the ones that I don't get through to today, I will put off on another Think of It Thursday. So today, again, I wanted to, let me just back up a little bit. So an interesting topic came up a few days ago where someone, and if you're watching or listening, thank you for the idea. Someone mentioned that her divorce is pending and she wanted to address some things that may come up that no one told her about, but for some reason she had the presence of mind to seek another attorney to help her take care of some things that may create an issue for her if something happened to her while the divorce is pending. So that's, first on my list. One of the things that she did was she sought out an estate's attorney and had them prepare for her a healthcare proxy, a power of attorney, and a living will. Now, depending on your estate, and most states fall under this guise, if a divorce is pending, just pending, not finalized, just pending, or if you're separated, whether it's a legal separation or just that you're living apart, or you're in the same house but you're living two different lives, that doesn't absolve your spouse of his or her legal right or obligation to make certain decisions. So if, God forbid, something happens to you catastrophic and you wind up in the hospital and there's a question of whether or not the plug should be pulled on you, your spouse is going to have that authority, while the divorce is pending. Yes, your spouse doesn't matter that again, that there's a divorce pending, your spouse will still have that authority unless and until you put certain vehicles in place to take that authority away from them. And that's where a living will comes in, with the DNR, do not resuscitate, power of attorney. I mean, living will is something that, depends on the state. They use different terminology, but living will or healthcare proxy or power of attorney, whatever it's called, you can delegate someone else the authority to make that decision or any healthcare decisions if you're unable to. Okay. And if you are, whether it doesn't matter what your age is, it doesn't matter what your health status is, it doesn't matter. If you are, at any phase or stage of your divorce and you know that, you would like someone else to make those decisions for you, then I suggest you take care of that. You have that drawn up. You can ask if you do have an attorney you're working with now. You can ask that attorney if they can draft those documents for you. I can't say most, but a lot of family law attorneys do have some experience and some knowledge of doing some transactional things like that, like drafting a will, a living will, power of attorney. That's what's considered transactional stuff. And most of the family law attorneys I know, they do those things because those things fall under the guise for some people of family law. So they do have some knowledge about those things as well. So you don't have to actually, hire a separate attorney to do that. You may, be able to have your current attorney, if you have one, to do them for you. Or I'm not a big advocate of using those legal Zooms, those kind of websites for certain things, because they don't necessarily tell you what nuances are involved in your state or in your case. But, for simple things like a power of attorney, a living will, healthcare proxy, those kind of things, yeah, you could, if you don't want to pay an attorney to do that, you can actually use one of those services. Those are pretty safe to use. If you have complicated, convoluted property or issues, then you may want to have either your attorney or another attorney do those things for you. So the other thing, and I'm jumping around for my list because, again, a lot of what I discuss happens to be based off of real life experiences. Whether I had a discussion with someone, I saw a post in a group, I had a chat with someone, a colleague or something. One of the things that's been coming up lately is it's the end of the tax year. Well, it's not officially end of the tax year, it's the end of the calendar year, but people are considering filing taxes. And one common question that I've been asked, or I've seen being asked a lot, is who gets to claim the child or the children, and while a divorce is pending. And technically, if you're still married, you cannot file as head of the household or as single if you're still married. By the end of the calendar year, if you're still married, then you're technically not supposed to file as single or as head of the household. You're technically supposed to file as either married or married filing separately. And whichever way is advantageous to you will depend on a lot of factors. I'm not an accountant, so I can't answer that. But I do know, technically, legally, you are not supposed to file anything but married or married filing jointly or separately. And if you are going to file separately, then you need to have a discussion with your soon-to-be ex about who's going to claim the kids or the kid. And one of the things I always recommend, I try to remember to recommend to people is that they have this discussion way before December 31st hits or January 31st hits, so that you can get an idea. You're not worrying, you're not trying to negotiate at the last minute and then you miss, the mark. This particular year has been a really important year because of the stimulus checks. I think I'm going to do a separate live on that. I think it depends. It's very convoluted, and so because of the stimulus, a lot of people feel like the stimulus. Let me back up. The stimulus for kids is based on who claimed the kids in the 2019 or the 2018 year. Okay, that's how the IRS determined who would get the stimulus for the kids. However, some people are saying or concerned now that even though they were together or they allowed their spouse to claim the kid or kids for 2019, that they didn't contribute financially to the taking care of the daily expenses or the monthly expenses for the kids for 2020. So should they actually reap the benefit of getting the stimulus, even though they didn't contribute to taking care of the kids or they didn't have custody for 2020? And what I believe happens is that if your spouse or soon-to-be ex claimed the kids for 2019 and they got the stimulus, both stimuluses in 2020, I believe you are allowed, and they refuse to give you your portion of it, which is your portion as a spouse, and or your portion because you're the primary caregiver for the kids. I believe the IRS has made a provision for that where you can contact them and you let them know what happened and they work it out. I don't know what they do. I've done a little research, and what I read is that what the IRS is doing is, for some families, they're actually disseminating 2 checks per kid. I don't know how true that is because I haven't seen anybody who said that they've actually that has actually happened for them. But I've read several sources where they say that that's what is possible to happen. So I suggest, if that's what is your particular situation, that you contact the IRS to see, to let them know that, because I think you'll get a credit or they'll wind up giving you, I don't know exactly what the intricacies are. And if I do a live, I'm going to actually do much more delving and exploring too before I actually discuss it at length. So, but anyway, so that was one of the things you would want to inform the IRS if you are in the middle of a divorce. It's okay to inform the IRS if you do not want your soon-to-be ex to claim the kids or the kid for a particular year while the divorce is pending. You can notify the IRS of that, and they will flag your kid's social security number to ensure that the spouse or your spouse doesn't claim them. Okay, you can do that. And if that's a concern, then I suggest you do that. That's another thing. You and let the IRS know ahead of time. As soon as you guys want, the other party is served and the divorce is underway, yeah, don't hesitate. Just get it done. One other thing I wanted to discuss, what a lot of people overlook, is life insurance. They forget to change the beneficiary on life insurance. And it's not that it's too late if you wait until after the divorce or post-divorce to do that, but suppose something happens mid-divorce and you intended to you or your spouse. I mean, right now I'm talking to you, so you should be more concerned about, if something happens to you and your life insurance, your spouse is the beneficiary, the proceeds going to your spouse, your soon-to-be ex, and you don't want that to happen. You'd rather it go to your kids or whomever else. So you want to change that. You want to change all life insurance policies to reflect that your soon-to-be ex is no longer to benefit from your demise. I mean, I hate to say it like that, but that's pretty much the way it goes. Health insurance coverage. If you've been carrying your spouse on your coverage. Now, this is a tricky topic because sometimes pending divorce, you're not supposed to change it. You can always ask for a judge's order, though. You can ask for almost anything in an interim. They call it interim relief. Interim relief covers health insurance coverage, auto insurance coverage, spousal support or maintenance, child support, extracurricular. During the interim, if you need certain things to continue or discontinue and you need the court's approval, you can ask for an order. That's what the interim relief orders are for. Interim means during, in the midst of. So you can ask the court for an order while the divorce is pending, and it can cover those things. A lot of times with interim orders, they will affect the final order. So in a lot of ways, sometimes the judge can decide coverage will continue while the divorce is pending. But upon the dissolution, the final judgment, whatever the judge allowed, he can decide that, it's self-executing. As soon as the order is issued, it ends, and vice versa. Also, they can credit someone. So if you're the one asking for interim relief, say you're asking for temporary, that your soon-to-be ex is to continue paying, I don't know, let me think of something, your car note. And then when the divorce is final, whether it be by settlement or trial, the judge can credit your soon-to-be ex for those payments and decide that now you are to take over those payments. It's entirely in the discretion of the judge. And a lot of things are based on fairness or equity, ability to pay, ability to, to maintain on your own. There's too many factors for me to go into right now. But a lot of people ask, oh, if I got a temporary order and the judge made him continue to pay my car payments during the divorce, but when it was over, he told me I had to take them over, and I don't think that's fair. Well, there are several reasons why. He might have thought, making $500 car payments for 2 years or 3 years was way more than you should have gotten in any divorce settlement. You know what I'm saying? There's a lot of reasons. There's a lot of factors, but my whole point is ask. If you need something and you think, your lawyer or someone had told you that you should not unilaterally either stop payment or continue to pay something, you can ask for interim relief. It's usually done by order to show cause, which is an emergency motion, petition, or motion. Depends on where you are. But the bottom line is and I'm bringing this up too, because I see, I don't know if it's just that it's just, people are just unaware of it, but I see so many people say, oh, I've been a stay-at-home mom for 12 years, 15 years, and he's not paying the rent or the mortgage and the car and the this and the that, and I don't know what to do. And I'm like, well, did you ask for interim relief? Did you make an application to the court to ask the judge to make sure he continues to pay those things? And half the time they're like, oh, I didn't know I could do that. Well, don't you have a lawyer? They didn't tell you that? No, they didn't mention that to me. Well, and I get it. Sometimes the lawyers assume that because there's 2 lawyers involved, they'll agree to that. No, I wouldn't. Some things I just wouldn't try to negotiate. And that's one of them. I'll negotiate after I file the motion, but some things I'm not going to try to settle. And that's not one. And mainly because, as I said, how that's handled during the divorce will more than likely impact what the final decision is of the judge of the court when the divorce is final on that particular issue or related issues, if you understand what I mean. So that's why. So if we settled something, if we negotiated something, if I was representing wife, And my adversary, the husband's lawyer, we talked about husband continuing to pay car note $500 a month, and insurance, which is $800 a month for the car. And later on, and we agreed to that. And then later on, he, when the divorce is almost about to be resolved, and he says, well, I can't afford $800 a month. And I say, well, wait a minute, you were paying it during the divorce. Why is it different now? Well, that was voluntary. I agreed to do that, but it's not because I wanted to. It's because I just agreed to that. No, you know what? Let me get a court order. Let the judge decide whether or not. Now it can, work in the flip for my client as well. But you know what? I'll take my chances. I always want a court order with something like that, because court orders have way more weight and effect than an agreement. Yes, judges do like to see you agree to certain things, but when, and for me, everything is strategy. Sometimes when you negotiate some things, they expect you to negotiate everything. And sometimes I don't want to negotiate. I want a judge to tell either me or my client, or my adversary and his client, his or her client, what it should be, how it should go. So that in the event that later on we wanted to, use that as a stepping stone, we need to enforce it, we want to appeal it, we have an actual order. The judge determined this. So, it has much more weight than us agreeing. So again, there's no two cases I do alike, I would handle alike. No two cases are alike. None of them. For me, everything is about strategy. And that's why sometimes I say maybe. No two cases are alike, period. I don't care what anyone tells you, they're not. The personality of the lawyers are different. The parties are different in their personalities. The judge can be the same, but the judge has, things going on in their life that affects how they feel that particular day or a particular day. No two cases are alike. That's just the way it is. So for me, everything is about strategy. I'm not focusing on the law and the procedure in a vacuum. Everything is looked at in a totality, in a contextual manner, so that we can decide, my client and me can decide the best strategy based on what's been happening up to this point. So I just wanted to put that out there. One of the things that a lot of people do not consider is, I do see it mentioned often, more so now, but leaving the marital home or leaving the home. I'm going to break that down into two. Leaving the marital home, that while the divorce is pending, if you decide to stay in the marital home with your soon-to-be ex, while the divorce is pending, you guys stay in the same house. If you try to bring up domestic violence, emotional distress, conflict, any kind of conflict, the mere fact that you remained under the same roof with your soon-to-be ex will have some impact on whether or not the judge actually believes you. It will. Whether they say it or not, it will. The moment the judge finds out, the divorce started 2019 of November, and it's now January of 2021, and the whole time you stayed in the home, doesn't matter what home, marital, rental, doesn't matter. The whole time you stayed in the home together, you can't decide in June, now you want to allege, he's really had conflict. He brutalized me. He terrorized me. He physically abused me. You can't allege that if you stayed in the marital home or the home. I keep saying marital home. If you stayed in the property, in the home, in the house, the apartment, whatever, with your soon-to-be ex throughout the whole duration of the divorce, while the divorce is pending, the likelihood of a judge believing that you were tormented for that whole time while you stayed there is slim. And I'm bringing that up because you need to think about that. if you need to leave, if you need to go stay with mom, if you need to go stay with your girlfriend, if you need to pile up in a 1-bedroom with, your sister, and you want to allege, some sort of abuse or neglect or torment or whatever, that kind of sort of gives you much more credibility than you staying in the marital home or the home with your soon-to-be ex during that whole time. Staying there for like a month or two, that's different. But if you're staying the whole time and you come in now alleging, he physically, sexually, verbally, now I have all kinds of emotional, psychological, and it's not to say that it doesn't happen, but I'm always going to speak to you guys from a judge's perspective, from a court's perspective. It's not about what I think. It's about what are we going to prove? What makes more sense to a judge who has 30 minutes to hear your case, make a decision, and move on. Okay. So during the pendency, if you know you are just been served or you're about to have him served, or you're just thinking about divorce, figure out if you are going to allege any sort of abuse, not just financial abuse, but any sort of abuse where you're going to ask the judge to, decide custody based on that, decide, property distribution and equitable distribution states based on that. You need to know that you are going to have to find somewhere else to live. You cannot share the same space with your soon-to-be ex and expect to benefit from allegations of abuse. I wouldn't take my chances. And if you had come to me when I was in private practice and said that, I would say, you know what, we have to find somewhere for you to go then, whether it be a DV shelter or wherever, you have to go somewhere else, because I know how to substantiate abuse cases. And one of them is you have to remove yourself from that situation, from that environment, so that you can at least have a leg to stand on when you make those sort of allegations. Okay. Another one is changing your job. Changing your job might be something you want to consider or not consider to do during the divorce. And there's a lot of reasons why. When you're changing your job, if you change jobs while the divorce is pending, that may or may not affect whether or not you can seek health care coverage, health insurance coverage to be continued by your soon-to-be ex, your ability to get child support, the amount that changes, that fluctuates, and spousal or alimony. Now, in some cases, you might have to get a job. And someone brought up in another group that I'm in, someone brought up that a stay-at-home mom, she was appalled that a stay-at-home mom who was married to her soon-to-be ex for 10 years, they actually just started a divorce, and who has spoken to a few lawyers, and the few lawyers that she spoke to told her that alimony is out of the question. It's time for her to get a job. So this person was appalled that her friend was told this. And I said, the reality is, you may be entitled to some sort of spousal support. Now, personally, from what she told me, I knew the reason the lawyers told her friend to get a job is because she wasn't entitled to any kind of maintenance or alimony or spousal support. So, even if she was, theoretically, you're entitled. Yeah, we know that. But logistically, if you need money right now to eat, to live, to get medication, to whatever, if you need money right now, yeah, you might have to get a job. You might have to change jobs. You may have to get another job. You may have to, it's not unheard of. If you decide, once the case is over, based on the outcome or the award you get, that you don't need to work anymore, or you can, become underemployed, or, do your own business or whatever you want to do, that's fine. But while the divorce is pending, yes. And a judge can actually direct that you get a job. So when it comes to that, if you're asking for any sort of financial support beyond child support, and that is going to be your sole source of income while the divorce is pending, you have to do the numbers. You have to do the numbers. You have to consider the number. You have to consider the reality, the realistic point of view. Yes, I believe stay-at-home moms should be awarded and compensated up the wazoo, especially if they stayed at home for more than 5 years and they were a homemaker and a mom and the house manager, whatever, all these hats that stay-at-home moms wear. Absolutely. However, that varies from state to state. It's not automatic. There's some states that rely heavily on the factors that the state allows them to. Some judges are more biased with some of them than others. I mean, some of the factors than other factors. So you have to be realistic, and you have to use a cost-benefit analysis. You have to decide. And that's something that I think any one of you who are stay-at-home mom or who are underemployed, there's a huge discrepancy in incomes. You need to do those numbers with your attorney if you have one. If you don't, I'm here for that as well. You can contact me for that as well. I can help you with that. We will factor in the cost of living, what you might get from him, how your earning potential, the job prospects in your area based on your skill and your education level, et cetera, et cetera, et cetera. But it's something that you should give your attention to. And that's why I'm bringing it up, because it's like people, a lot of times I see people, it's like an afterthought to them. It's like, I don't know if they watch TV and they think, oh, I've been a stay-at-home mom, I automatically get money. And as soon as, whether it's issued by a temporary order or by final judgment or by settlement, oh, as soon as he leaves or as soon as I leave, he's going to start paying, or he's going to continue to pay, and I'm going to be fine. No. I rarely see, even when they're ordered to pay by the court, I rarely see where the payor spouse pays the payee spouse the way they're supposed to. I rarely see that. I don't care if the two attorneys worked it out. 75% of the time I see there's some issue with the payor spouse paying on time, the amount they're supposed to pay, and maintaining some consistency with that. There's always an issue. So you know what? Just prepare yourself. Just consider what you're up against. Consider the numbers, play with the numbers, factor it in, factor the worst case scenario, get it out of the way so that you're not coming at the 11th hour saying, okay, I have an eviction notice on my door. What am I supposed to do? The car company is about to come repossess my car and I need it to take my kids back and forth to daycare or to school. What am I supposed to do? No. Figure all of that out beforehand, before you get to the point where you're begging and borrowing and stealing. You're not going to steal, just to maintain your living expenses. So I'm going to go through two more, and then yes, I am going to continue this on next week's live because it is already 4:38. And anybody have questions, please feel free to post your questions. Another thing I wanted to bring up is the dating during divorce. Oh, I cringe when I see people bring in a boyfriend or whatever we're calling our significant others these days. But I cringe when I see people get involved too early, and too early means custody hasn't been resolved. Visitation hasn't been resolved. Those kind of things. You should not be bringing a relationship into the fold. You shouldn't. Not if you know that you're in a highly contentious divorce. No, it only complicates things. It does. It complicates custody. It complicates visitation. Whether it's a temporary order or final order, it just complicates things because you have a boyfriend now. Now your soon-to-be ex is, he's or she is upset that you have someone else around their kids or coming with you to pick up and drop off or whatever it is. You know what? Do me a favor, and I know I am a hopeless romantic. I am. But I just don't recommend that. If you can avoid it, don't recommend it. Please, I avoid it at all costs. If it's meant to be, they'll wait. They'll at least wait until you have the settlement worked out. If the case is going to trial and one of the issues for trial is custody and or visitation, wait. If you want to have a dalliance and it's like literally someone who doesn't come around you while you have your kids, doesn't come to your home, your soon-to-be ex doesn't know about, that's different. But I'm talking about a paramour, a significant other, definitely not someone who's going to move in. No. I actually did a blog about that topic yesterday. So if you want to read my blog, it's on my website, www.thedivorcesolutionist.com, and go to my blog page. That this week's blog was on that topic, dating during the divorce or something like that. But anyway, I go into some reasons why that is a huge no. Not to mention, it's adultery. It is adultery. And even though I'm talking about during divorce, so chances are whoever filed has already chosen their grounds. Procedurally, you can amend your petition to add adultery, or the other party who is the defendant or respondent, depending on where you are, whatever it's called, they can actually ask for leave of the court to file their own cross petition for divorce and allege adultery. Just don't bother. Just wait. Just wait, please. The other thing I was going to mention is a lot of times, one major thing that people don't consider, and this came up too this week, is the information gathering. Everyone is like, I hear it a million times a day. Document. Everybody's always telling people, document. Document everything. Everything. Just document it. Wherever you are, whatever's happening, just document. That means absolutely nothing. Yes, I agree, document. But what does it mean? What can you document? How can you document? How can you admit it? Yes, document. But have a plan with your documenting everything. Have it worked out. What are you going to do with it? Is it legal? Will it be admissible? Is it an admissible form? How do I organize it? Start to focus on that as well. So when you're documenting stuff, and if you're working with an attorney, you should have a session, what I call a strategy session. Yes, I'm a big believer in having strategy sessions with your lawyer, where you focus on, the evidence, the information you've gathered, whatever it is, whatever the source, that you actually weed through it, you organize it, you arrange it, you whatever, put it in date order. That's what I'm trying to say. You need to do that. I wouldn't do that on the eve of trial. I wouldn't do that. I would prefer that we do this when some way midway, so that you'll have an idea of what it is that goes where, what it is too much, is unnecessary, is illegally obtained. I would prefer you start to work on that during. Again, when I say I'm talking about when I was in private practice. Now that I don't do that, and it wasn't easy to do that with a busy caseload. So sometimes I had my paralegal or my assistant do that. And we didn't do it for every case. I'm not going to kid you. We didn't do it for every case. We only did it for the cases that were really where the outcome hinged a lot on that kind of stuff. But if you have an attorney, you should work on that with them. During the divorce, you need to have an idea, again, and I mentioned this several times. For me, I want you to gather whatever you can gather. If I were your lawyer, yes, document everything. But I'm telling you, as a divorce strategist, coach, and consultant, make sure you have a plan with everything that you're documenting and you're gathering. Make sure you have an idea of how it can be used, if it can be used at some point. And it doesn't hurt to have more than less, but it can hurt you if you gathered stuff that is useless and now you've wasted time. Because the more evidence you bring to your lawyer, the more they're going to charge you, because it's more they have to sort out. So you need to get an idea of what goes where, whether it's legal, how to do it properly. And again, that's one of the services that I offer. I do evidence organization, trial preparation, all those kind of things. So I'm going to end it there. I'm sorry I have to be so abrupt, but I am on a tight schedule today. I will pick up next week with the other things, and I might add some things onto this one, as a matter of fact. So again, I am Tracy B at thedivorcesolutionist.com. You can find me in I just started another group. It's really for really just for pro se litigants who are going through divorce or custody. It's called Pro Se Divorce and Custody. You can find me in the Divorce Glow Up, which is the other group that I run, thedivorcesolutionist.com. I have a Facebook page, The Divorce Solutionist, on Facebook. I am on Instagram. But you can also DM me. I am always accessible via DM, email, divorcecoachesq@gmail. I can be found. Anyway, if you need help with, my new workshop. I forgot to mention my new workshop for New Jersey residents. It's a pro se divorce workshop for New Jersey residents. I'm going to do that live. We're going to go through each step of the uncontested divorce process for the state of New Jersey. We're going to do that live. Seats are limited. It's February 1st at 6 p.m. Eastern Standard Time. It's $99. Yes, $99. Yes, it's only $99. That price will change. This is the first one that I'm doing. So it's like a beta launch to see the interest I actually get. So if you are in New Jersey, you have a truly uncontested divorce, and you want to save hundreds, even thousands, because I hear lawyers are charging like $1,500 and up. $1,500 and up for uncontested divorces in New Jersey. If you want to save, that is the course for you. I will send you the forms in advance. I will give you instructions as to how to prepare for the workshop in advance. It's going to be live on Facebook, February 1st, 2021, this year, 6 p.m. on Facebook, Eastern Standard Time, that is. If you're interested, I'm going to add the link. Well, it's on my page, so the link should be everywhere. And I have an ad floating around somewhere on Facebook. So anyway, until next week,